To our August webinar, Family Immigration and Citizenship Basics. Thank you so much for attending. We look forward to providing, hopefully, information that will be useful for you in some way. But before we get started, I just want to be sure that everyone is able to hear me. So if someone would just put in the chat, yes, if you're able to hear me, that would be great. Thank you. All right. So a little more housekeeping, just in this format. Some of you have attended our webinars before, but for those of you who haven't, just wanted to let you know that you can ask questions at any time during the webinar. And to do so, if possible, if you see your Q&A icon sort of at the top right of your screen or somewhere on your phone, if you're watching on your phone, try to enter your questions there. But if not, you can always enter also in the chat button as well. But regarding your questions, we do ask that for confidentiality purposes, since this is sort of an open forum and your questions can be, I think, seen by others, just try to keep it general as possible and not provide personal details. Okay, so next I just wanted to briefly introduce our firm, Badmus Associates. We have worked with thousands of clients since 1993 and have been fortunate to be recognized in various publications on various lawyers lists, such as Best Lawyers in Dallas, as well as one of the best law firms in immigration in the Dallas-Fort Worth area by U.S. News and World Report. And then finally, before we get started, the last notice I want to give you is to let you know, of course, that this presentation is really for educational purposes. It's information, not advice. Immigration is very, very complicated. And so while it may seem that there are many similarities between cases, usually there is a unique factor in all of those. So it's very important that this information is helpful, but it should be used in conjunction or in consultation with the immigration professional who can tailor it to your specific situation. So our agenda today, as the title implies, is that we're going to talk about how to help your family legally immigrate to the U.S., or how someone who is a family member of a U.S. citizen or permanent resident can immigrate to the U.S. And then we'll also talk about citizenship as well for those who are eligible, what the basic requirements are, and the process for U.S. citizenship is. And then finally, we will answer any questions that are posted in the chat or the question and answer panel towards the end of the presentation. So starting out with how to help your family legally immigrate to the U.S. So with family immigration, it typically, there really is not a temporary type of visa for someone to immigrate as a family member of a U.S. citizen or permanent resident. The only way really to immigrate is to be able to get permanent status or the green card, which of course is the ideal situation for those who want to be here permanently in the U.S. So how does that happen? And more specifically, who can sponsor a family member to become a permanent resident in the United States? So as I mentioned earlier, there's just really two categories of individuals who can do this. And one would be a U.S. citizen, whether born in the U.S. or whether naturalized citizen, or someone who also has a green card, is a lawful permanent resident. The difference is there, as you will see, there is a lot more availability or more more availability for family members, or a wider range of family members who can immigrate based on a U.S. citizen as opposed to a permanent resident. So that brings us to the first category of family members that I want to discuss, and that is what we call immediate relatives of U.S. citizens. So what that immediate relative is an important category, and it actually is a category that is has a lot of benefits. Of course, the first criteria is that the person who is applying for the family member must be a U.S. citizen. So the person they sponsor, it would be considered an immediate relative. And the reason why that's important is because immediate relatives, there is no limit to the numbers of people who can be sponsored as immediate relatives. Whereas, as we'll see in the next few slides, there are limitations for those who are not considered immediate relatives. So there are basically three categories of immediate relatives. The first one that many people are aware of is a spouse of a U.S. citizen. So if you are a U.S. citizen, or if you marry a U.S. citizen, then you would be eligible as an immediate relative to get permanent status or that green card based on the sponsorship by that U.S. citizen. So the spouse, who qualifies as a spouse? Well, of course, there must be a marriage. So that marriage must be official and legally valid in either any state of the United States or the foreign country where the marriage ceremony was conducted. So that's number one. Of course, there has to be a legally recognized marriage. And then secondly, you have to show that that marriage has been entered into good faith, or what they call a bona fide marriage, meaning that the marriage was entered into purposes other than to get permanent residence for that spouse. So this, how do we prove that? And this is probably the most important part of the process, because getting the marriage certificate, it's typically not difficult to get married in the United States or anywhere else. But in order to prove that it is a valid marriage, you do have to, at least in the eyes of the U.S. government, prove that you have a marriage, a real marriage, a bona fide marriage. And the way that they determine that is by looking really a lot at documents. So the more documents you have to prove your valid marriage, the stronger your case will be, the fewer questions that will be asked. So listed on this slide are some of the typical documents that the government expects to see whenever you are proving your marriage case. So of course they want to see that you are living together. If you are in the United States together, they want to see that you are living together. And the way that they see that you or that you can prove that is either having a lease or a deed for your residence that shows that both of you are at that residence, or on the lease or on the deed for that residence. They also like to see joint bank accounts, joint insurance coverages, health insurance, auto insurance. If those are things that you have, they would like to see that the spouse is covered by those insurances as well as the U.S. citizen. Definitely like to see pictures, including wedding pictures or other pictures of you together as a couple with other family members, showing that you are publicly acknowledging to the world that you are a couple. So the more pictures you have, especially wedding photos, the better, or the stronger case you have. Another financial document they look for, of course, is joint tax returns. So assuming that you have been married long enough to have a tax return together, they like to see that you have filed together as a married couple. If you have children together, then certainly that's probably the best proof of a valid marriage. So definitely would want to provide any birth certificates of children that you have together. And another way that some people who may not have as many documents as we've listed here can also provide notarized letters, or what we call affidavits from friends and family, acknowledging the marriage and describing your relationship. Now, this is not an exhaustive list. There can be other ways to prove, if, for example, things like you get mail at the same address, your driver's license or ID has the same address, all those things. So again, but the more you can provide of this information, the more likely your application will be approved. The other point to make here is more recently just to backtrack a little bit, typically when you do apply as a spouse of a U.S. citizen, there is always an interview. So if you, you more than likely there will be an interview if you are applying. However, recently we have seen that if you have a lot of good evidence submitted with your application, then sometimes the interview is waived and you can actually be approved without having to go to an interview, which is always a benefit because you don't have to take that extra step. But in most cases, it's totally discretionary with the government, but you can be required to interview in order to, again, answer questions about your marriage. So it's very important that you you and your spouse attend the interview and be able to answer the questions that may arise at that interview. We don't have enough time to go into the very specifics of that. We can probably do a whole webinar on this category alone, but I just wanted to give you this basic information as a start to that process. Another immediate relative would be parents of a U.S. citizen. So oftentimes we get asked by potential clients whether or not, because they have children who are born in the U.S. and are U.S. citizens, whether or not those children can sponsor the parents for permanent status or the green card. And the answer is yes. However, the children have to be at least 21 years of age. So if they're under 21, there's nothing that they can do in terms of sponsorship. But once they do turn 21, then they can apply for their parent to get permanent status. So basically, in order to prove that, it's very important to prove the parental relationship. And of course, documents are necessary for that. So the government expects you have to present the birth certificate of the U.S. citizen child. And that birth certificate should be detailed to show the names of the parents. And the birth certificate should be registered as close as possible to the date of their birth. If that is not the case, I know we do have some clients who are naturalized citizens and were born outside the U.S., and oftentimes there is not a birth certificate, or a birth certificate was registered much later, even as an adult, as the person was an adult. And in that case, the birth certificate alone would not be enough to prove that relationship. The government would also want to see secondary evidence, which could be things like an old hospital record, an older religious record, a school record, and school meaning like an elementary school record or a primary school record. And if those aren't available, most of the time we will have affidavits, notarized letters by relatives or other people who were there at the birth of the child or knew about the birth of the child. So we will sometimes need to get that as well. Interestingly, if the father is the sponsored parent, you do need to present a marriage certificate between the parents. If it's the mother, you do not have to provide a marriage certificate. But if the father is being sponsored, a marriage certificate between the parents at the time of the child's birth needs to be provided. Or if the parents were not married at the time of the birth of the U.S. citizen, then you must prove that the father supported the U.S. citizen child before he or she turned 18 years old. So that requires a lot more evidence, such as financial proof, other types of letters, things to show that the father was involved in the life of the child before they turned 18. And then the last thing sometimes does happen when these records fail or it becomes some issue that is more difficult to prove by documents, then a DNA test is sometimes required or can be used to prove that there is the relationship between the parent and the child. One thing I don't have on here, which I do want to mention, is that a stepchild can also sponsor a step parent, assuming that the child was under the age of 18 at the time that the child's parent and the step parent got married. Okay, another immediate relative category is the reverse of that, which basically means that we show that a parent, a U.S. citizen parent, is sponsoring a child. So a child that's under the age of 21 and unmarried is considered an immediate relative, and a stepchild is also considered an immediate relative if that child was under the age of 18 when the parents married. And then adopted children are also considered immediate relatives of U.S. citizens if adopted before the age of 16, with some other conditions as well. I won't address that part of it. I really wanted to just explain the evidence that's required to prove that if you are a U.S. citizen applying for your child, what you need to provide in order to do that. And so basically it would be a birth certificate of the child. So having the names of the parents, and again, registered at as close as possible to birth. If not, then if the birth certificate was not registered near birth, then that secondary evidence, as I mentioned in the previous slide, should also be provided. And if the U.S. citizen father is the sponsor, kind of the same thing we talked about where the child is the sponsor, then marriage certificate needs to be provided between the parents. Or if the parents were not married, proof that the father supported the child. And again, DNA testing may also be required. So those are the immediate relative categories. And as I mentioned earlier, there are benefits to that. So the main benefit to the immediate relative category is that there is no limit on the number of people who are, if you're immediate relative, there's no limit on the numbers of immediate relatives who can immigrate from any country. There's no waiting list. So it's really just a matter of processing time for that person. Processing time, though, can vary, and depending on where each person, where the sponsored individual is living. Also, immediate relatives, if you have the advantage that if an immediate relative entered the U.S. legally, lawfully, they came in, for example, as a student with a student visa or with a visitor visa or some other work visa, but somehow that visa expired and they did not leave. The interesting thing about that is that that person can still become a permanent resident and apply in the United States for the entire process. They do not have to leave the U.S. In fact, so we have people who have been out of status, been here, overstayed for 10 years or more, but they were still able to do adjustment of status, even though most of the time you cannot do adjustment of status unless you have maintained legal status for the entire time. So immediate relatives can be out of status. As long as they've entered the United States legally, they are able to apply for adjustment of status, even if they've overstayed for long periods of time. That is not the case for other categories, as we'll talk about later. So the other categories of family applications that are available would be what we call the family preference categories. And these are distinct from the immediate relatives, mainly because of the categories and the types of sponsorship, but also there is a limited number of green cards available each year for these categories. Therefore, there always is a waiting list, and the waiting list depends on the category that you're in. So I have listed here what we call the FB, family-based categories 1, 2, 3, and 4. And those are dependent on the relationships between the sponsor and the family members. So for family-based 1, these are unmarried sons and daughters of U.S. citizens. So what do I mean by sons and daughters? Sons and daughters are any children that are over the age of 21. If they're under the age of 21, then they are immediate relatives. But once they turn 21, they become daughters, and that means that they are no longer able to avoid that waiting list. They are now put onto the waiting list of this category FB1. So if you're applying for a child that is over the age of 21 and you're a U.S. citizen, then and they're not married, they will be placed on the FB1 category. The other category is the FB2. Now, this is the category of spouses and children of permanent residents. And that's broken down into two subcategories, FB-2A, which is for spouses and children of permanent residents. Spouses and children under the age of 21 of permanent residents. And the FB-2B is only for children, unmarried children over the age of 21, who are unmarried children of permanent residents over the age of 21. So that's a separate category as well. The third category, FB3, is married sons and daughters of U.S. citizens. And then FB4 is brother and sisters of U.S. citizens. So as you note here, U.S. citizens can apply for married children. They can apply for siblings. However, permanent residents, LPRs, can only apply for spouses and children, spouses and unmarried children. So that's important to note. And the next thing that's really important to note as well is that, again, the son and daughter must be, if you are in the FB1, unmarried sons and daughters of U.S. citizens, the son or daughter must be unmarried at the time the application is filed, and they have to continue to be unmarried before they can get permanent status. And this is interesting because sometimes the government actually, we had a case where many, many years ago, someone was one of our clients did apply and did receive their permanent status based on being an unmarried sons and daughters. However, they had gotten married before they actually immigrated to the U.S. So technically, they should not have received permanent status. They've lived here for many years in their permanent status, and we're told eventually that you're not a permanent resident because that was mistakenly granted to you since you were not married, since you were married at before you entered the U.S. So this is a very, very important detail, that if you are applying for a U.S. For a son or daughter and they're unmarried and they want to immigrate under this category, they must be unmarried up until the time they actually get their green card. After that, of course, they're free to get married. But also, if an immediate relative child, immediate to relative petition has been approved for a child under the age of 21, but that child turns 21 before they have filed the adjustment of status application, then they're converted to the FB1 category, which means now they're placed on a waiting list. So whereas before they were not on a waiting list, they are now on a waiting list. So it will take longer for them to get their permanent status. So if you have a child that's under the age of 21, it's important to be sure to, at least if they're in the United States, also apply for the adjustment of status, the I-485 part, as well as the actual application by the U.S. citizen, which is called the I-130. And if there's an approved FB1 petition and the son or daughter marries, then the petition is converted to an FB3, which is a married son or daughter. And that could mean a difference with a couple of years in terms of processing. So I've been talking a lot about waiting lists. And so we're going to talk more specifically about what that means, especially in the family category. So the waiting list is developed because, as I mentioned, there is a limited number of immigrant visas. So immigrant visa is the same thing as a green card. It's just another word for that. So for an immigrant visa, or for someone to be eligible to receive a green card, they must have what's called a current priority date, which means that their U.S. citizen or a permanent resident spouse must have filed for their green card before a certain date, and what we call the cutoff date, which is found on the visa bulletin that the government issues every month. That visa bulletin is how they track whether or not a green card is available for those people who have applied. So the visa bulletin, as I mentioned, is issued every month. There's a website here. You can just Google visa bulletin, and it will lead you to the website where you can find the monthly visa bulletin that's issued by the Department of State. And so this is a upcoming September visa bulletin I have on this slide. And as you can see, it is broken down. Our bulletin is broken down into several categories. So it's important to know how to read this chart. So typically what you have to do is know what category you're in. So this family sponsored category is broken down to the F1, F2A, F2B, F3, F4 that I mentioned earlier. Then it's also broken down into country of birth. Now, The numbers of green cards available under these types of under the visa bulletin is based on country of birth as well as the category you're in, because all the green cards available each year are supposed to be equally divided amongst all the countries in the world. And because you have countries that are much larger and have more higher rates of immigration to the US, you have those countries broken out into their own separate columns: China, India, Mexico, and Philippines. And then everyone else who is not born in those countries, and this is the relative, the sponsored relative who is not born in China, India, Mexico, or Philippines, is under what we call rest of the world, or all chargeability areas. So if you are from, let's say, if your sponsored relative is from Nigeria, then you would be looking in this category or this chart. And you can see that the cutoff dates here give you an idea of how long it would take for your relative to get their actual green card. Let's go with the worst category, or the worst waiting list, which is the brother or sister of a U.S. citizen, the F4 category. So as you can see here, even for all of the rest of the world category, the cutoff date is April 7th, 2020. I'm sorry, is that 2022? Okay. No, I'm sorry. It's April 22nd, 2007. So that's how they designated. So April 22nd, 2007 is the cutoff date. So that means that only those applicants who were sponsored, or their U.S. citizen sibling filed their application before April 22nd, 2007, are now able to actually immigrate with their green cards. So you can see right there, that's about 16-year waiting list for that category. But it can be even worse for other countries, such as Mexico is almost a 23-year, it's actually a 23-year waiting list for that category. So it ranges as well. So essentially, as you can see, this is a very disheartening chart at sometimes, because it does look like there's quite a bit of waiting time for different categories. Even for spouses of permanent residents, it's a waiting time of 2018 for those who applied before 2018, January 2018, or December, or applied on or before December 31st, 2017, are now able to get their green cards. So it's very important, if you have relatives that you're sponsoring or you're being sponsored in any of these categories, to check these the Visa Bulletin monthly to see where you are, and trying to get an idea of where you will be able, approximate idea of when you will be able to get your green card. So other important facts about the Visa Bulletin: again, priority date must be before the cutoff date. It is based on the place of birth, country of chargeability. You have those 4 categories. It is very unpredictable. It does not move in a line every month. So sometimes you will find that it's the same cutoff date for months and months at a time. Sometimes it will go backwards and retrogress, as we say. So, for example, the FB2 category was current, meaning that there was no waiting list for quite some time, but now it's developed into a waiting list back to 2018. So if you are planning to apply for your family member, these are the basic steps to apply. And a lot of it depends individually on where your family member lives, what country they are from, what your status is as well. So if you're applying based on being a U.S. citizen or permanent resident, first thing you have to do is you do apply in the United States. So you submit what's called the I-130 petition. You file that with the USCIS, and then you wait for their decision. Now, you wait for the decision on the I-130 unless you're in the immediate relative category. And if you are actually in the United States as the relative, and you're an immediate relative, and you have entered the United States legally whether or not your legal status has expired, you are able to apply for adjustment of status. So you can also do the I-130 and the I-485 concurrently at the same time. If you are under another category or not an immediate relative, then you have to be sure that your priority date is before the cutoff date on the visa bulletin before you can actually apply for adjustment of status. So, for example, if your application was applied for in 2017 as a spouse of a permanent resident, and you're now legally in the United States, you have maintained your legal status, and you want to apply for adjustment of status, then you can potentially do so. Even with the you can potentially do so, assuming that your priority date is current. Also, the alternative to adjustment of status is the DS-260 immigrant visa application. And this is for people who either cannot adjust their status because they don't have the legal status in the United States, or they are outside the United States and are, this is the only way they're going to be able to come to the US is by applying for the immigrant visa. But again, the priority date has to be available. So that means you are eligible now to take up one of those green cards that are available. And then you would apply at the US Embassy through that DS-260 immigrant visa application in order to get your permanent status and come to the US as a permanent resident. So you can see it can be pretty complicated, and it really does depend on the individual circumstance as to how long it will take, what process you can use. So there are a lot of different variables to look at. One other important part for any family application to know is that when you are at the adjustment of status or the immigrant visa stage of the process, the US citizen or permanent resident family member must provide an affidavit of support, or what we call an I-864 form, because they must show that there is sufficient support, financial support for that sponsored family member, so that the family member is not likely to become what's called a public charge, meaning that they would not be using government funding to survive. So it's very important that if you are the sponsor, that you have your tax returns ready to submit, filed and ready to submit, employment verification information, or if you're self-employed, bank accounts or other kinds of proof of your self-employment, and be able to show that you meet the minimum income levels required so that they can see that you have enough to support that immigrant family member. Now, when I say support, I don't necessarily mean that the government is saying you have to provide income or have that person living with you or anything like that. What it means is that the intending immigrant, the immigrant family member who comes to the US is not able to start using government funding for their survival, because the government is going to say that you have a family member who have said that they were going to provide that support, so you're not eligible for certain government benefits. So that's really the main purpose of the affidavit of support, but it is very much required. If you do not have the minimum level of income that's needed, or assets that's needed, then you will, in many cases, need to have a joint financial sponsor who, in addition to the U.S. citizen permanent resident relative, must provide their minimum income or income information. So just to give you a basic idea of the income levels for this year in particular, the minimum income level that's required for a U.S. citizen or permanent resident to prove would be based on the household size. So let's say it's a married couple and there's only a family of, there's only two in the household. Then the minimum income would be $22,887 that the U.S. citizen or permanent resident must prove. They must prove that they get at least around $23,000 each year of income. As the household size increases, the more and more relatives that are living, or the more and more people that are living and are being supported in your household, then the income level increases. So if you have a family of 5 with 3 children, then your income level has to be $40,587 to meet that requirement. So this is the chart that the government uses to determine whether or not there's sufficient income of the U.S. citizen permanent resident to support the sponsored relative. And then finally, before we go on to citizenship, I wanted to talk about inadmissibility. So inadmissibility is important because even if you do qualify as a family member, you may still be denied a green card because of certain past history that the government considers to be problematic. So, for example, if there are certain crimes that you have been convicted of, whether in the U.S. or outside the U.S., that can make you inadmissible, meaning that you will not be approved for the green card, regardless of your status or relative relationship to your U.S. citizen relative. If you have misrepresented or what the government considers been fraudulent in other visa applications, for example, in a visitor visa, they determine that you were not truthful, or any other type of visa, or even in a previous application, they determine that you were not truthful, then you can also be denied the green card. If you have what's called unlawful presence, meaning that you overstayed or you entered without overstayed a legal entry, or you entered illegally and stayed for a year or more, you can be denied the green card. There are some exceptions to that. We don't have time to go into all of that, but that is a basis of inadmissibility. But again, it's on a case-by-case basis, so you definitely need to consult. If you feel like you might have unlawful presence, you would definitely need to consult with an attorney to determine whether or not that would be a bar. If you were previously removed or deported, that can also make you inadmissible, even if you have a U.S. citizen relative that qualifies. If you have a J-1 visa, which required you to go back home for 2 years before you can get a green card, then you would be inadmissible unless you did indeed go back home for 2 years, or you got a waiver of that 2-year requirement. And then there are some other miscellaneous grounds, like certain medical grounds, depending on the seriousness of the medical condition, those types of things. So those are all things that need to be considered. And as you apply for an immigrant visa or adjustment of status, those are questions that are asked so that the government can determine whether or not you are admissible to the U.S. So as I keep mentioning, be sure that if you are looking to either apply for a family member or you are being sponsored by a family member, that you get qualified help at least to determine your eligibility, determine whether any issues could be a barrier to your permanent residence, and also determine what the exact process is. So next we'll go on to how to become a citizen. And before I go on, I just want to be sure everybody can or be sure to enter any questions that you have into the Q&A panel, and then I will be answering them. I see one here that's related to citizenship. So I will briefly answer that. It's asked, I've met the requirements to file the N-400. Do I require the service of an attorney? What would you recommend? Well, I would love to say that you require that, but it is not the case. There's no requirement that you have an attorney sponsor. We do help our attorney help you with citizenship. We do help many clients with that process for various reasons, for their own comfort level, as well as time the time that they need to prepare for that. Also, there may be issues if you have certain issues. So, for example, if you've traveled extensively, that may be an issue. Travel internationally extensively, an attorney might help you to clarify whether or not that could be an issue for your application. So, if you feel you qualify and there's no issues related to your application, then it's probably very doable on your own as well. So that being said, let's go into what are the qualifications for citizenship or naturalization. So naturalization is the process of someone who was not born in the U.S. or not derived citizenship by some other way to actually apply to become a citizen. So to be naturalized, you must be 18 years old, at least 18 years old, and you either have to have been a permanent resident. Now, there are exceptions, but we're just talking about generally. So you have to have been a permanent resident for 3 years if you are married to a U.S. citizen for the entire 3 years, or 5 years. Most people will fall into the 5-year category if they're applying based on employment, or they applied and got their green card based on employment, or sponsorship by a parent or something like that. You will usually be a 5-year time. However, if you were married to a U.S. citizen at the time you got your green card, and whether you got it through employment or whether you got it through sponsorship by that U.S. citizen, you could be eligible in 3 years. Or even later, if you were sponsored, but your U.S. citizen, your spouse became a citizen and you lived with them for 3 years, then you could actually apply earlier than the 5-year time. So that's why it's important to look at each circumstance to determine, your eligibility on that. But what's also very important is that your residence must be continuous, because certain breaks may break the continuity of residence. So this is where we often get questions like, well, how long can I be out of the United States for 6 months, a year? How, if I want to be a citizen, how long can I live outside the U.S. or travel and stay outside of the U.S.? So that is very important to track and be sure that you are during this 5-year period, not breaking your continuous residence. So continuous residence is considered any travel outside the U.S. for more than 6 months. So if your trip is 6 months or more, then you are considered to have broken the continuous residence. Now, it doesn't mean you're not eligible. You can still be considered eligible, assuming that it's less than a year that you've been outside the country. So if you're 6 months, between 6 months and a year outside the country, it's still possible that you could be eligible. However, you must prove that you maintained your residence in the U.S., you filed your taxes in the U.S., you had no intent of leaving or residing outside the U.S., that your trip was really temporary in that sense. Even though it was long, it was still temporary. So you must show the really strong ties that you have to the U.S. during that time that you were outside the country. So ideally, it's best not to try to stay out of the country any more than 6 months at a time. We advise to basically stay under that 6-month mark. If you want to take a long-term trip, stay under 6 months. That's going to give you a better, or least trouble in terms of, or least fewer questions in terms of naturalization. The other requirement for naturalization is actual physical presence. So if you are, whether you're basing your citizenship eligibility on 5 years or 3 years, you have to show at least half of that period you were physically in the United States. It can be cumulative. It doesn't mean you have to be 36 months continuously in the United States, but cumulatively over the 5-year period, you spent at least 36 months in the United States. So you really need to make sure you track the time, especially if you do have frequent travel, international travel, you do want to track the time that you were here to show that you had that physical presence. Another factor that is very important is the good moral character. So the good moral character has what's called a look back period of 3 to 5 years. So if you're applying based on the 5-year qualification of being a permanent resident, then they're going to look back for 5 years to see whether or not you had any issues, such as any arrest, any failure, for example, to pay child support, things like that. You will see on the N-400 naturalization application a lot of questions that they ask, which are related to good moral character, so that they can determine whether or not you have good moral character. So it's important that you answer truthfully on those. But if you do have a situation where there's been an arrest, or even an arrest, even if you didn't even if it was expunged, or even if it was dismissed, you still need to disclose that. And you do want to keep records of the dismissal or the expungement, because the government will ask for those. So even though you may be told that this should not be on your record, it will show up for immigration purposes. Naturalization also requires that you speak read and write English. So there is a test, and you can get a lot of that information online as far as the testing is concerned. Typically, it's a list of 100 questions that the government can ask you at your citizenship interview. They will ask 10 questions and will expect you to get 6 out of those 10 questions correct. Now, if you are unable, there are certain exemptions from the English testing. So if you're 55 years or older and have lived in the US for 15 years or more, then you don't have to do the English test. However, you do have to take the civics or the government testing in your native language. If you are 50 years or older and has lived in the US as a permanent resident for 20 years, then you can take the civics test in your native language. If you're 65 years or older and you've lived as a permanent resident for 20 years or more, then you can take a simplified civics test in your own language. So those are things that is simplified, meaning it's not as complex as the other ones. So that's important to know. If you are not under those exemptions, then you do have to be able to take the English test as well as the government civics history test and pass those. Now, there's one other exemption, which is if you can be exempt from the English testing or even the overall testing if you have physical or developmental disabilities that have lasted for 1 year. So at least 1 year before applying for citizenship. So this requires a doctor's report, an exam and doctor's report to show why you are unable to take the English and government testing. So if you feel that you're in that category, if you're working with someone who's in that category, make sure that you get a qualified physician or psychologist to complete that form and verify that that you as an applicant cannot take the testing. So if all goes well and you pass the history and civics tests, unless you're exempted somehow, then at your citizenship interview, you will be told whether or not you have passed everything. And if you have passed everything, the next step is the oath of allegiance. And that is when you actually become a citizen and get your citizenship or naturalization certificate. We are seeing now in many cases, the processing is pretty quick. So I'll talk about that a little later, but oftentimes the interview and the oath of allegiance can be done on the same day. So that would definitely be an advantage to be able to do that same day, but sometimes it's not the same day. So you can have the interview and the oath of allegiance can come a month or 2 later. So just be aware of that. Now, there are some bars or sort of like inadmissibility exemptions to your eligibility for citizenship. So even if you're a permanent resident, you may not be able to become a citizen if you have had any issues, including good moral character. That's one, but there are some more egregious kinds of issues that the government says you will never be able to become a citizen. For example, a permanent bar, of course, is that you are convicted of very egregious acts such as murder, aggravated felonies, anti-government acts, support violent overthrow of government. So those are very, very serious crimes, of course. So they will never allow citizenship for anyone who's been convicted of that. But then there are also temporary bars that may not necessarily exclude you immediately, but or not necessarily exclude you forever, but they could exclude you immediately. So, for example, when you apply, if in the past 5 years you have, engaged in any of these kinds of activities, such as prostitution, habitual alcoholism, I guess they say habitual drunkard, but I think that means alcoholism, polygamy, even shoplifting, and a couple of other things, then you can not be approved, and you will have to wait until it's been more than 5 years since that offense took place. And let me see, one last section of statutory bars. There is a discretionary bar, discretionary meaning that the officer that is interviewing you can use their own discretion to determine whether or not they're going to consider you to be ineligible for citizenship. So some things, like as I mentioned, non-payment of child support, extramarital affairs can be considered. It's rare, but it does happen. Failure to register for selective service if you were required to. Males under the age of 26 who became permanent residents under the age of 26 usually have to register for selective service. So failure to do that could also cause an issue, also cause denial of your citizenship application, and then tax violations and some others as well. So these are all things to think about, and those are questions that will be asked on your application. So if you have any of those kinds of issues, then you do want to understand the risk to those. So definitely consult again with an attorney to understand that if I do apply, what could happen. So let's say that the government, you're a permanent resident, and some of these things have happened. You might have committed some certain offenses that could be considered very hard, could be considered a bar. So in some cases, it's better not to apply at all, because if you do apply, now the government is going to actually observe and see those kinds of offenses. And so in that case, not only could you not naturalize, but they could decide to revoke your permanent residence altogether, put you in removal proceedings. So there could be a lot more repercussions than just the denial of the citizenship application. So who should not apply? If you've had an aggravated felony conviction, probably you should not apply. There's a false claim to citizenship, and unlawful voting. Now, that I should not say who should not absolutely apply. If you have a false claim to citizenship or unlawful voting, sometimes depending on the circumstances, those can be waived, or the government can decide to still approve you, but they are very, very serious allegations or serious parts of the application. So you want to be sure that you consult with an attorney to be sure that how you could avoid that situation, or how you can overcome that kind of circumstance. Another is if you are known to have, or if you had given false or misleading information on your green card application, and your green card application was approved, that could, when you apply for citizenship, that can be brought up again. So the government can now has another chance to ask you the same kinds of questions. And, if it looks like there was false information given earlier, they can deny the application. And it could also lead to revocation of your green card. If you've convicted of a crime of moral character within 5 years of coming into the U.S., that can also be a basis for denying citizenship. And if you have a criminal conviction and still on parole, that can be another basis. So procedurally, you essentially would complete and file an N-400 once you are eligible, and you can apply 3 months in advance of your 3 or 5 year anniversary of the green card. They don't require a lot of documents. So basically a copy of your green card, copy of all passports that you use in the past 3 or 5 years. Even if the passports are expired, you want to provide those, especially if they have any travel stamps on them. Right now, the fee for applying is $725 unless there's a fee waiver. And then you usually get, once you apply, you can apply online or apply by mail. You get a receipt, and then you get a biometrics notice to take fingerprints, or they might say you no longer have to take fingerprints because we're going to use your past fingerprints we had from your green card application, for example. Ideally, you would have an interview within 3 to 4 months. That's based on current times. We are seeing very quick interview times. We've seen even less than 3 or 4 months, but on average, I guess currently they don't guarantee it, but it's about 3 to 4 months that you'll have an interview. And then if you are able, if there's availability at your interview, you might actually have an oath ceremony that same day, and that's when you become a citizen. Or if there's not availability on the same day of the interview, you will get a notice for a future date where you will attend a group oath ceremony and get your certificate of naturalization. So that's the procedure for naturalization. But the last thing I just want to go on before we answer questions quickly, I see we have a few, is that there is an automatic citizenship. So those of you, especially who have children who are permanent residents and they're under the age of 18, this is a really good benefit that if you are able to get your citizenship before the child turns 18, and the child is unmarried, then they will automatically become a citizen. So they do not have to have a separate naturalization application when they turn 18. They will become a citizen the day you become a citizen. There are some qualifications to that, but that is the general idea, is that you can do that. If your child is born abroad and you're a U.S. citizen, then that child usually can be is a U.S. citizen as well. But if that happens, you want to be sure to visit the embassy and establish the citizenship of that child and get a U.S. Birth record from the embassy. All right. So the last thing is proof of automatic citizenship. Either you get, as I mentioned, a certificate of citizenship for someone who is considered a citizen. They don't have to go through the naturalization process, but they are considered a citizen by deriving it from a parent or some other circumstance. You also, other proof of citizenship is if the child is born of U.S. citizens abroad, they get a consular report of birth abroad. And then you have the U.S. passport as something everyone should get as quickly as possible after getting their citizenship. That is this, you don't have to get a certificate of citizenship. You don't have to get a consular report. Well, you don't have to get a certificate of citizenship for a child who is automatically a citizen upon your naturalization. You can just go directly to getting a U.S. passport. It's faster, usually cheaper, and it's the same proof as any other, as a certificate of citizenship. All right, so now we come to the question and answer section. Let me just go make sure I have all the questions. Okay, so I see some in the chat. Someone's asked, what is the eligibility of applying for green card in the States? So I'm not quite sure what detail you're looking for, but essentially, if you are here legally and you're applying through family member, depending on what category you're applying in, you might be able to do the adjustment of status process. So for example, if you are married to a U.S. citizen and you came in legally, then even if your status expired, you are eligible to do adjustment of status immediately as an immediate relative. If you're a permanent resident, or spouse of a permanent resident, and you're here legally, you have to wait until the priority date of your spouse's application for you is current, so that a green card is available, and the government says you can now apply for your final step, the adjustment of status. So it depends on each person's situation. The last question I have here is when can someone start the process of applying for citizenship when their green card was granted in October 2019. So depending on how you got your green card, so most of the time it's 5 years from the time you received your green card. So look on your green card for the exact date that you were granted permanent residence, and then count 57 months from that date. So calculate 57 months, which is 3 months before your 5-year anniversary. So the government allows you to apply 90 days in advance of your 5-year anniversary. If you have a 3-year anniversary because you're married to a U.S. citizen, then you can apply 3 months in advance of your 3-year anniversary. So look at your card and determine that date and be exact, because if you apply before that 90-day period, they will reject it, or even if they don't reject it, and accept your fee and accept your application, later on they will deny it. So you want to be sure you're calculating that very precisely. Okay, the last question I see is where should I go, what website to check if my status is current or not to apply for adjustment of status? So that would be the visa bulletin. Let me see if I go back. It's actually this presentation is recorded, so you should be able to see it, but I'm trying to go back to the visa bulletin. So here we go. So on the visa bulletin, if you look on this slide, and you'll see it's a pretty long website, but I would just Google visa bulletin. Visa bulletin, and if you Google that, you should be able to pull up the visa bulletin from the Department of State. There is also a USCIS visa bulletin. That's the one that really tells you if you're in the United States whether you can adjust status. So you would just basically Google USCIS visa bulletin, and it will take you to the adjustment of status filing charts. So that's another really long website. So it's hard for me to say that, but what I will try to do right now is to put it into, let's see, the chat, and maybe you can get it from there. So I've added it there, so hopefully that will be helpful to you. Okay. So I don't think I have any other questions here. So it is 2:00, so I want to thank you all for spending the time here today. Hopefully this has been informative for you. Finally, again, I want to remind you that this is that we are basically providing information and not legal advice. As if you've listened to my presentation at length, you'll know that I do emphasize to contact an attorney because every situation is different. But hopefully this information has at least given you some things to look for and keep you informed so that when you do discuss with an attorney, or even if you apply on your own, you have a basis for doing so. So thank you again for attending our website, our webinar, and you all have a great day. Thank you.